Begin.
Good afternoon, everybody, or late good morning. My name is Henry Shapiro. I am an associate at Jackson-Lewis, Long Island. I will get started right away by saying I am not Chris Valentino. He is in sunny California right now, but I am in sunny New York, allowing all of you to hear this wonderful presentation. So to start, it's a big day. It's June 30th. It's Friday. It's July 4th weekend. There's a lot going well, and there's a lot coming out on New York's paid family leave. The reason June 30th is a big day is July 1st is the day that employers can start taking deductions. So we're going to get into that, but this is probably the hottest issue in New York employment law right now because it's going to affect everybody. So we'll start with my fun play on words of what's cool for the summer. For any Demi Lovato fans out there, we're going to go over updates on New York's paid family leave benefits law. So we'll go over with what you know first, and these are going to be the basics. Everybody already knows the general pieces of the law, how much time is covered, how much it's going to cost. So the intro information, the New York paid family leave law takes effect on January 1st, 2018 for all private employers with at least one employee for 30 days in any calendar year. What's important about that? It covers everyone. So there's really no private employer here that is not covered under the paid family leave law. So if you think it doesn't apply to you, for whatever reason, feel free to reach out, but more likely than not, it is going to be every New York employer is covered under this law. By 2021, the reason why 2021 comes up, even though it is only the early year of 2017, this program is going to be phased in over the course of 4 years. It's going to start this year or next year, 2018, with 8 weeks of leave where employees can get 50% of their salary up to a cap, the cap being the average weekly wage. 2019, so a year after that, it's going to kick up to 10 weeks of leave for 55% of the employee's wage, average wage to a cap as well. 2020 kicks up to 60% of the wage, still stays at 10 weeks. 2021 kicks up to the full 12 weeks, as the slide says, and 67%, essentially 2/3 of an employee's average wages are going to be available for paid leave. So you'll see at the bottom, the part that is scaring everybody, prepare for a potential administrative nightmare. I put potential to try to lighten the blow, but this is going to be an administrative nightmare, but we're all going to face it together. So how much will this cost? June 1st, so the last couple months ago, Chris gave a presentation on this regarding what we knew of paid family leave at the time. Things have changed, things have evolved, we've learned more. June 1st, New York State released the contribution rate. You can call it the deduction rate, however you want to phrase it, it's going to be how this program is funded. We've heard all along it's a 100% employee-funded program, but what we didn't know is how much funding is coming from these employees. So the statistic, the fund number, 0.126% of an employee's weekly wage, not to exceed 0.126% of the New York State average weekly wage, may be deducted from an employee's paycheck for paid family leave. If it's weekly, bi-weekly, that doesn't matter. It's still going to be the same percentage of the weekly wage. The average weekly wage is reevaluated by the New York State Department of Labor every March 31st. So the importance of that is every year, more likely than not, this is going to go up because the average weekly wage is going to go up. So the deduction for employees is going to go up. So now what? Based on the formula, the maximum contribution rate for an employee will be $1.65 a week. And if you look at the smaller bullet point, you'll see how we get to that number. The New York State average weekly wage right now, as of this past March 31st, is $1,305.92. 0.126% of that number is $1.65. It works out to $1.64.5 and a bunch of decimals. If we round up, we get to $1.65. That's going to be what we're looking at for January 1, 2018, but that's the maximum. Again, that's not going to be the deduction for everybody. So this is not easy in the way of New York State statutory temporary disability or short-term disability. The little 60 cents deduction you see come out from every employee's paycheck, that's a set flat rate for everyone. This will not be. You might see some employees with deductions of 30 or 40 cents. You might see some employees with deductions of $1.65. Right now, come January 1 of 18, No one's going to be above $1.65 because that's going to be the maximum. So here's where tomorrow's date of July 1st becomes big. Contributions may begin on July 1st, 2017 for coverage that will begin on January 1st, 2018. Now, the reason why this is a hot issue at the time is A, it's tomorrow, and B, there's a lot of questions about why. If the coverage doesn't start until January 1st, why would I, as an employer, why am I taking any money from my employees prior to January 1 when the coverage begins? The philosophy behind it is the New York State Workers' Comp Board feels that employers should not have to pay anything for this. That was what Governor Cuomo proposed, that this will be a 100% employee-funded program. In order to do that, employers need to pay insurance premiums. The paid family leave coverage is going to be a rider on their DBL policy. So your DBL is your short-term New York State disability policy. Now you're going to have a rider, so you're going to have an increased premium on your insurance policy for paid family leave. How do you pay that? With these employee contributions. So if your policy comes due at the beginning of the year, annually, January 1st, 2018, you have to pay your entire premium for paid family leave coverage. New York State wants you to have funds accumulated in a little pot where you are able to pay for your premium. So that's the fundamental reason for the July 1st, 2017 date. Do you have to take it as of July 1st? No. Are you out of compliance with the law if you don't take it on July 1st? No. The issue may be is come January 1st, if you have not taken deductions, you very well may need to pay out of pocket or an employer may need to pay out of pocket in order to finance the premium, and then they can essentially reimburse themselves with the employee's contributions. So this is basically a way to try to make it more cost effective for employers. There's no wrong answer when it comes to whether or not I should take the deduction on July 1st. It's voluntary, and some of the misinformation out there is that it is required for employers to take this deduction. It is, as the law is currently written, as the regulations are currently written, and I say currently because everything is still in a proposed state other than this 0.126% contribution number. Everything is proposed, so everything is still subject to change, and we're going to get to that in a second. But the reason behind the January 1st enactment, the July 1st contribution date, is the administrative cost here cannot be accounted for. That's going to come with tracking leave, providing notice, talking to your attorneys about how to execute a new law properly. That's not employee covered. The deductions are only allowed to be used to pay for your premium. If you collect more than your premium cost from employee deductions, then that money must be refunded. How it's going to be refunded, we don't know, but that money has to be refunded. We're going to learn more, we assume, as these regulations move towards a finalized version. So as I said, it's still evolving. On May 24th of this year, the New York State Workers' Compensation Board released updated or revised regulations following the closure of the notice and comment period from the original proposed regulations. So they're still proposed, but now they're slightly newer. The revised regulations allow for a comment period. The comment period closed a week ago, last Friday, June 23rd. So the original comment period closed April 8th. It took us about 6 weeks to get new guidance or revised guidance. We don't know when to expect anything from this June 23rd closure. If it's on the same schedule, it would look to be early August that we would hopefully hear something. But we're going to await that. We're going to see what changes. It's still unclear if the next level of guidance is going to be the finalized guidance. Obviously, they do really have up until January 1 to get this finalized. So we will stay tuned. The revised regulations provide some clarification on language from the original regulations. As you'll remember, and as Chris alluded to in an earlier presentation, there is a lot of confusion regarding some of the language in the regulations currently. There's still confusion, I hate to say it, in the revised regulations, but we did learn a little bit more than we knew before. So one of the things that changed with these May 24th revisions is the eligibility criteria. The original regulations defined full-time employee, part-time employee. Part-time employee was defined as somebody who works fewer than 5 days a week. So you'll see I have nurses listed there. The reason I put nurses is a nurse, for those of you that know, will typically work 3, maybe 4, 12-hour shifts in a week. And that is technically fewer than 5 days in a week. By the way the original regulations were written, that person would be a part-time worker. We all know that they are not part-time at that level, that they are working on a full-time schedule. So to avoid this apparent contradiction, they removed the terms full-time and part-time. So now it's defined on a level of hours. So if you have an employee working over 20 hours a week, for our purposes, we can call it full-time. The regulations don't refer to it as full-time, but over 20 hours a week is a full-time employee. That person is going to need to work 26 consecutive weeks to be eligible for paid family leave. On the other side of it, if the schedule is less than 20 hours a week, that person needs to work 175 days in order to be eligible for paid family leave. Now, you'll see consecutive 52-week period, unclear. The issue here is the regulations, again, as currently written, do not say it must be a 175-day period in a consecutive 52-week period. There's parts of the regulations that say the 175 days must be within a consecutive 52-week span, but this specific part about eligibility criteria in the regulations just say if you work less than 20 hours, you must work 175 days. It doesn't say, it doesn't limit it to a time frame. We would expect that that gets clarified in the next version of the regulations because it's fairly consistent throughout the rest of the guidance, but right now it's still sufficiently unclear. So one of the big things that came out and one of the questions that we got a lot over here was FMLA, paid family leave, the interplay between the two. Is there one? Is there not one? Are they the same thing? Obviously, they're not the same thing. One is a federal law, one is a state law. Obviously, paid family leave being New York State, FMLA being the federal government. They do have many similarities. One of the qualifying reasons that you could take paid family leave is a qualifying military exigency. That tracks the language from the FMLA. Both of them give leave. Obviously, one is paid, one is unpaid. So there's similarities, there's differences. But there was one main inconsistency, and I was present for Chris's presentation, and he actually alluded to it on the call. When originally, the regulation stated that an employer, I should say, cannot mandate or cannot require an employee to use their paid time off while on paid family leave to essentially give themselves a full salary. That could not be compelled. The FMLA, for those of us who work in FMLA covered workplaces or run FMLA covered workplaces, we know that the FMLA provides that you can compel an employee that is taking FMLA leave to use accrued paid time off and to essentially lower their balances, charge their paid time off. The revised regulations clear this up because there's clearly reasons where an individual can take leave that is going to concurrently run under the FMLA and the paid family leave. So how can you allow for the FMLA to say, yes, you can charge their time, paid family leave says, no, you can't charge their time. So now when an employee is eligible for leave under both the FMLA and the PFL, so it must be a reason for leave covered under both laws, the employer may charge the employee's accrued paid time off in accordance with the FMLA. So essentially what the revised regulations say is in a situation where the leave is covered under paid family leave and under the FMLA controls. So an employer can do what it does under the FMLA for paid family leave. If it's a paid family leave only absence, as you'll see by the third bullet point, employers may allow an employee to use their accrued PTO if that's their policy. However, they cannot require. So if it's a PTO only reason, for example, if you are caring for a family member that is not for a serious medical condition for a family member that is not covered under FMLA, such as a grandparent, then you cannot force them to use their accrued PTO. If they say that they want to, then you're more than allowed to give them that opportunity, but you cannot compel them to do so. So what about unions? This, I'll just glance over quickly. An employer who provides paid family leave benefits under a collective bargaining agreement, a CBA, is relieved from providing paid family leave if the benefits are at least as favorable as benefits under the paid family leave law. Essentially, you can't take any shortcuts here. You are allowed to not essentially enforce paid family leave if your CBA, which most CBAs are not going to talk about this yet because this is a new thing. If your CBA, so if you're entering negotiations now, this might be something you want to start thinking about. If your CBA provides for similar benefits, nothing less, it could be more. You can give more leave, you can give a higher percentage of salary, you can give more weeks off, but you can't give anything lower. Then you don't need to comply with paid family leave. You can bargain the terms amongst the parties. Now, a CBA may provide rules related to paid family leave that differ from the paid family leave law, but the time period for eligibility cannot exceed either 26 consecutive work weeks or 175 days. So you can't make it where it's longer for an employee. It now takes longer for an employee to become eligible for benefits. That is something you can't do. You can't now say it's going to take a year for you to get eligible for this. That would be violating the law. Employee waivers. Originally, employers maintained an affirmative duty, and this is kind of a nuanced aspect of the paid family leave law and the regulations. They maintained an affirmative duty to provide employees an option to file a waiver to exempt them from making contributions for paid family leave coverage if ineligible due to their regular work schedule. The point of the paid family leave law is not to allow employers to find ways to get employees out of this. It's not for employees to find a way to get out of making the contribution. The goal of this is to cover as many people as possible. And as we said earlier, it will cover as many people as possible. The only people who can waive their contributions and do not have to have the deduction taken from their wages, which we said will be a max of 165, the only waiver of this is coming from individuals whose regular schedule will never make them eligible for paid family leave. So if it's a person who works more than 20 hours a week and they are not going to work 26 consecutive weeks. So for instance, as we get to the summer, a seasonal worker, then they are not eligible for paid family leave. They will never be eligible for paid family leave under that schedule. You don't have to take the deduction. They can waive out of the deduction. The revised regulations say an employee of a covered employer may be provided the option to file a waiver of paid family leave. So now, the original regulation stated that it was an affirmative duty from the employer. It does not appear any longer that the employer is required to alert the employee. However, it's still a best practice to notify the employee if their schedule is never going to allow them to collect paid family leave benefits. There's nothing wrong with telling the employee, and it's probably a best practice to tell the employee that, hey, you have the ability to waive out of this law, to waive from giving these contributions. Put the decision in the employee's hand. The waiver form is coming soon from the board. It's not out yet. It's something that they're going to release a draft. The workers' comp board is going to release a draft form, and that's essentially what we're going to use. Schedule changes matter. The reason I raise that is schedule changes. If somebody's regular schedule changes and they then become eligible for paid family leave, then it is on the employer to essentially revoke the waiver, start collecting deductions, and then go back and see if there's any time that they should have been collecting deductions retroactive to the date of hire. That's still a little bit of a gray area based on the current regulations, but there's going to be, again, some administrative legwork for an employee that was eligible to waive and now their waiver is now revoked. Intermittent leave, this is a big question we get. Intermittent leave is permissible under the paid family leave. There's nothing currently saying that in the regulations that you could take leave of less than a day at a time. So it doesn't look like you can take 4 hours of leave. It looks like it's got to be full day increments. And the revised regulations allow an employer to require employee notice as soon as practicable before each day of intermittent leave. Originally, the regulations just said you had to give it once, and then the employee could take intermittent leave as they wish. Now, if foreseeable, before each day of the leave, the employee has to give fresh notice. So to end on a happy note, after all of the administrative undertakings that everybody's going to have on this call, we go with the July 4th reference of what fireworks are next. So basically, what do we do from here? We await the release of the common responses following the end of the comment period on June 23rd, 2017. So that might provide new guidance. It might provide further clarification to some of the questions that you have, some of the questions that we have. what we've said all along to anybody who we've spoken to, what Chris said on an earlier presentation: contact your New York State temporary disability insurance carrier, contact your payroll company about the permissive July 1st, 2017 deduction. Again, that's tomorrow. Obviously, this is a big date. If you want to start taking the deduction, reach out to your counsel, figure out what it is that is required. I will tell you there's no affirmative requirement to provide notice to the employees. However, once again, best practice, and when I say notice, there's no affirmative requirement to provide notice of the deduction to employees. There is going to be a notice requirement with the paid family leave law come January 1st, but as a best practice is recommended to notify the employees of the deduction so you don't face a line of an angry mob outside your door saying, my paycheck just went down, what happened, what'd you do, give me my money. So now we await the release of the waiver form. The paid family leave request, the waiver form, again, we talked about is going to come out from the board. The paid family leave request forms, which are the forms that employees can use to request leave. There's going to be a different form for each category of leave, for baby bonding, or for bonding leave, we should call it, for qualifying military exigency leave, and for caring for a family member. There's going to be separate forms for each. And the notice is going to be required from the board in order to post in the workplace. So there's other parameters to it. 20 minutes is never going to be enough time to cover everything, but as you know, if you have any questions, you feel free to submit them. And I wish everybody a very happy and safe July 4th holiday weekend, and thank you very much for attending.